Hi there, and welcome to Boomer Time Season 2. I'm your host, Nancy Cogar, as you know, and I'm so glad you're here. Hey, it's Season 2, and I am so excited about that. We are going to have a whole year more of going over complex legal issues, things you're thinking about, problem situations, making sense of issues that come up as you age. So I hope you'll stick with me this year. I'm really excited about the interviews, resources, all kinds of things that I'm going to bring your way. So while I was on holiday, I started to think about how I was going to start this season. And I thought, maybe we'd start with some questions that have come up, people who have reached out to me, listeners, fellow listeners. And they've curious about some things, confused about other things, and these might be issues that you've thought about too. So I thought it would be helpful if I gave my 2 cents to some of these questions that I'm going to share with you today. So I would start with question number 1. And like I said, these are real life situations that I hear about all the time. So don't feel bad if you say, ooh, that's me, and I can't do anything about this. That's not true. The whole purpose of this podcast is to make you more aware of some of these things and show you there are options to take care of them. All you need to do is act, right? So, question number 1. My parents are stubborn and stuck in their ways. Well, guess what? My parents are too. And yet I see them declining, and I'm concerned about them being taken advantage of or not being able to keep up on bills and things like that. Nancy, what can I do? They are not agreeable to sign powers of attorney. Well, this is something that comes up all the time. And like I said, my parents are used to things the way they've always been, right? Most of us are. But when you start to decline, and even before that, you're going to want to put some things in place so that you have trusted people making decisions for you if you're not able to make them. That is my number 1 objective when I have you sign powers of attorney. We're not taking away any powers from you. We're actually just thinking in the future when you may not be able to make those decisions and putting someone you trust and love in charge so that it's effective, it's got the authority it needs to get those things done, and you know who's making those decisions for you, right? So there's nothing to be scared of. I know sometimes, losing your independence or even questioning that can be scary. I get it. But I'm telling you, this is worthwhile. So if you sit down with me, that is what I'm going to do when it comes to powers of attorney. So maybe that kind of conversation can help with some of the stubbornness or reluctance. Sometimes it's the messenger, right? You will always be their child. You may be 50 plus years old, but you're still going to be their child. So maybe think about a different messenger. Maybe get on the phone, schedule a strategy session with me. That may be just the way it needs to go. So I'd be happy to do that. But the main point in this question is you need to put those powers of attorney in place. They need to be specific and they need to be enforceable. And you need to do it before you need the power of attorney. Okay, so you need to have the capacity to be able to sign these documents. I hope that makes sense. Good question. Okay, number 2. I had a will made several years ago, and I can't find the original. Okay, that's important, so we're going to talk about that in a minute. What should I do? Can I use a copy? Well, I want to tell you something right off the bat, okay? If you can't find your original will, you really need to make a new one. Because here's why, okay? There is a presumption under the law in this state, and, there may be one in your state if you're not here with me, that if you do not have the original document with the original signatures and the original notary, all that, there's a presumption that you revoked it. You tore it up. You didn't want it anymore. So That's not good. And that's just going to create another problem for your family when they try to probate your estate. So you said, can I use a copy? Well, you can, at least here you can, but before it's enforceable, I'll say, you or your family, because you're going to be gone, your family is going to have to file another legal action in court to prove that the copy is enforceable and that you did not revoke the document. So bottom line, that leads to more cost, more time in court, more frustration probably, The easy thing to do would be, if you can't find your original, make a new will and do it the right way, okay? Chances are, if you made it several years ago, you said, it may be more than several years ago. It probably needs to be updated, right? So that's my advice as far as that's concerned. 3, hey, this is a good question. 3, what is the difference between a will and a trust? And how do I know whether I need one? That is an excellent question. So they are very different. A will, like we just talked about, a will is only effective once you pass away. So I think of a will as kind of directions for what you want to happen to your stuff after you die. Okay? It does not take effect until you die. So you can revoke it up to that point, if you have the capacity, of course. You can change it, you can amend it. That's what sometimes leads to all these disputes, right? Because you maybe had one decision in one will, and then you changed your mind, and you had another decision in another will. So if you do revoke it, get rid of it. I'm telling you. Okay, so a trust is, I liken it to a contract. So a contract or instructions as to what you want to happen to your stuff. But you can manage it now as a trustee. And then when you're not able to do that anymore, you don't want to, or you die, then you put a successor in place. Maybe a son, daughter, so forth, that becomes the trustee when you are no longer the trustee. And they follow the directions for what you want to happen with your property. And trusts are great because you don't have to go to court. You keep it in the family. You keep it private. You don't need to ask a court for directions to do something or permission, right? It's all effective, hopefully, if you've done it the right way. And your trustee has the orders from you as to what you want to happen and when. And you can put some very specific things in there. Of course, there are revocable trusts, irrevocable trusts, just like they sound. Revocable, you could revoke, you could change it, all that kind of stuff. Irrevocable, those are more creditor protection trusts. And once you make them, you can't change them. So, all right, these are 3 really good questions. So I look forward to moving through this list. And like I said, I'm so glad you're here on Boomer Time. Stay with me, okay? Well, welcome back to Boomer Time. This is season 2, and I am Nancy Cogar. So glad you're here. And we are talking about questions that have come up from fellow listeners like you, and what I would say about the scenarios that they're bringing up. So I think this would be helpful to you. You may have some of the same issues. These things come up all the time. So question number 4. I am looking for ways to prepare for the possibility of nursing home care for my husband. That's a scary place to be, uncomfortable and strange. So you're doing the right thing by reaching out. He has an account in his name alone that has about $100,000 cash in it. And I'm afraid that may be subject to a spend down before he can qualify for any assistance. What should I do? Can I gift this money to our grandchildren? Oh, That is a very important question, a very complex issue that may come up in your life. And this is the kind of thing I can help people with, and I have helped people with. Her husband may not have the capacity anymore to make estate planning documents. That's why you want to think about, what may come up in the future and talk with someone like me as far as how would you handle a situation like this, right? Okay, so here we are, and she's preparing for the possibility of nursing home care for her husband. So, yes, if you have $100,000 in cash sitting in an account for purposes of eligibility for assistance through Medicaid or TennCare, that money is absolutely going to be counted and probably subject to a spend down. I say that with one caveat, okay? Because if there's a spouse at home, a community spouse is what they call you, you get to keep some things, okay? But there's a whole calculation that you have to go through. And if this is your husband's account, chances are, yes, it will be counted. Now, depending on how much time you have before he goes in a nursing home, there's some things you can do. You can make some improvements to the house that might help him and delay his entry into a nursing home. You specifically asked whether you could gift the money to your grandchildren. Well, you can, but I would tell you in this instance, you want to be careful because those gifting strategies, they count as transfers too. So they're going to ask you, why did you gift that $100,000 away? So if you got 10 grandkids and you give them all $10,000, you're probably going to have some splaining to do when that comes up. But like I said, this is the kind of issue that you're going to want to sit down with someone like me and talk about strategies. Okay. Number 5, what could happen if I don't agree to make powers of attorney? Okay, this is on the opposite side of the fence there from our adult child that was asking about their parents not wanting to sign a power of attorney. So what would happen if I don't agree to make a power of attorney? My doctors already know my children and talk with them when I go to appointments and when he calls. Isn't that good enough? Short answer, no. No. Because this may have worked back in the day. I know things used to be a lot simpler. But now and today, in the age of HIPAA, privacy actions, things like this, you do not want to create a situation where your children may not have the authority to talk with a doctor about your treatments and don't have the authority to see your medical records. You need a power of attorney, okay? And you need to make it now. Number 6, my brother died recently. He lived in Texas with his wife. They had no children, and I don't think he had a will. How can I find out whether there is anything that's supposed to go to me or my mom? I hear this one a lot too. Okay, so if he didn't have a will, I'll tell you right off the bat that Texas law will control in terms of who gets what. So the first thing I'd do is maybe talk to an attorney in Texas about what that tree looks like. Okay, I know what it looks like here, and if there are no children, no will, then the wife is most certainly going to get probably the bulk of the estate, maybe all of it. Mom could be an heir at law if wife wasn't there, but depends on how long they were married too. That can make a difference, okay? But how do you find out if something's supposed to go to me or my mom? Most of the time, that would be if there was a will, okay? Because he would have to specifically provide that you get this and your mom get this. And that's not out of the question. That can happen. And if it is the case, then you are required to get notice under due process, right? Constitutional due process. So you're supposed to get notice of the petition, the estate being created, and the will. Now, I want to mention one little thing. So what if no one, let's say surviving wife, does not file a probate? It doesn't mean that there's not a will. It may just mean that she doesn't want to present it. You have the right to create an estate if you want to. You could petition the court at that point, and you could require any kind of estate planning document, will, be presented to the court. Here, it's I believe, a Class D felony if you hide a will or destroy it. So that's serious. I think that brings some jail time. So this is serious stuff. So I don't know. That's a tough one. I deal with that with probates from time to time. But my first indication to you would be to check and see what Texas does. Okay, and then go from there. I'm sorry about your brother. Okay, this one. I want to spend some good time on this one. Romance scams. Boy, oh boy, I see so many people getting tangled up in these things. So mom has a boyfriend online. She doesn't like to talk about it. Of course she doesn't. And I've let it go for a while. But recently, I went over her house and a bank statement was on the kitchen table. I was shocked to see all kinds of debits to an online dating site. What can I do? So I want to take this in two pieces, actually, because this is an issue that comes up all the time and it can cause big, big problems. I've seen one woman in particular. Her daughter called me, tried to do something about it. Her mom wouldn't listen. They left her to her own devices, and she spent all of the money that was in the bank account and ended up having to sell her house and move in with her daughter. Just wrong. Okay? These people are scammers. But to my point, I wanted to say, let's take it in two pieces. Okay, so unfortunately, if you're competent, you're, a competent adult, you have the right to make bad decisions. We learn from our mistakes. You can make a bad decision. And, your family sometimes has to live with that. That's painful. But here's what's even more painful. If someone is an older adult, say they're vulnerable, say they've, got some decline, say they're being taken advantage of by these, what I call predators, online predators, then you have a couple of options. You can try to talk to your mom about it. If you have a power of attorney, you can let her bank know and start minding those finances. Put a limit on debits. They'll go away as soon as the money stops coming. If you don't have any of those things, you're really potentially looking at a conservatorship. So if mom won't comply, she's got some competency issues, and you don't have a power of attorney, unfortunately, sometimes the best option is a conservatorship, and that is a petition to request that the court take rights away from your mother. That's not fun either, but sometimes that's the only option. Well, before I go on with these questions, we've got about 3 more. I'm just going to take a quick break, okay? I'm going to have a sip of coffee, adjust myself in the chair, and I'll be right back. Hey, welcome back. I hope you're enjoying these questions. I always learn things when I hear from you, and I enjoy seeing what you're concerned about, what you're wondering about. You're out there, you have a question, send it to me. Go to nancycogar.com and send me your question. Hey, I may talk about it on an upcoming episode. And you could help other people and be part of that conversation. That's important. I'm trying to build community here, right? So let's get back to the questions, okay? So number 8, this is a good one. Okay, what's the best way to avoid probate? Can I just quit claim my house to my kids? No, 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 please don't do that, okay? You are creating a big problem. So don't quit claim your house to your kids. And here's why. If you quit claim your house to your kids, you just transferred away probably the biggest asset that you have, the most valuable piece of property that you own, for nothing, right? So you gave it away essentially to your kids. So what happens if down the road you have to get some skilled care and go into a nursing home and you need to apply for help? Well, you just created a huge issue by quit claiming your house because you transferred away the biggest, most valuable asset that you have. And it may cause problems both for eligibility and for your kids. Okay, they could set that transfer aside. They could issue a penalty period. That means you have to pay up to a certain time. Here's the other issue. If you quit claim your house away to your kids for nothing, you have now given away what is called your step-up in basis, which means whatever you paid for your house back in the day, say you paid $25,000, and the house is now worth $225,000. You gave away that step up to that value. Don't do that. Okay? There's some things we can do here, but don't do that. And you asked, what is the best way to avoid probate? Well, there's easy and effective things you can do with beneficiary designations. Okay? And you can make a will. You know, it may or may not have to go through probate. Maybe it's a limited probate. You can create a trust. Trust can avoid probate. So there are all kinds of things you can do, but you have to do them the right way. Okay? So I definitely would say do not just give your house away. Okay? Number 9, help. Oh, this is a big one too. Okay? Help. My father won't give the keys up to the car. I went over to his house and I noticed that the car has several long scrapes of red paint on the side, like he hit something. Seen that before. I'm afraid that he may do something worse. What can I do to get the keys taken away from him? I bet some of you out there have been through this. This is not an easy situation. Cars represent independence, and when it gets to a point when you're arguing with them about them driving, it can be really tense. Sometimes they shouldn't be driving. I absolutely agree. And taking those keys away can be difficult. One thing you might try, you might talk with his physician, tell him about your concern. Hopefully you have a healthcare power of attorney, and tell them what's happening. They can issue a prescription, actually, or an order to have you go, or have your father go take a driving test. There's a driving assessment test that Siskin Hospital here in Chattanooga offers, and I'm sure there's hospitals that offer the same thing in different counties around here. So I would look into that, because then if he fails, they have to take the keys away. It's out of your hands at that point, right? That's a suggestion, but that's not an easy one. All right. And the long scrapes of red paint, yeah, maybe they're judging of how far things are away isn't as good as it used to be. And you really want to be careful, right? Because if they do hurt somebody or hit something, not only have they hurt somebody and hit something, it could raise a huge liability issue. Okay? You don't want that for them. I know transportation is hard. I know there's not a lot of options around, but maybe you can work something out where somebody in the family offers rides a couple times a week. Maybe they can do Uber. And there are also some other options with, ride shares and things like that. So, and if they move into an independence facility, sometimes there's buses where they can take you shopping and take you to the doctor, that kind of stuff. So there are options. It's just looking at things that are new and different and trying to figure out what the best option is. Number 10, this is my last question that I have here. I do not have a lot of money. Several years ago, I made a will in my own handwriting. Will that work to have my few assets conveyed to my 2 children when I die? Short answer on this one is yes, probably. So this state does honor handwritten wills. They're called holographic wills. And they have to be entirely in your handwriting. They don't have to be witnessed. You do have to sign it. It's good to have a date on it. But number one, it has to be a will. You have to acknowledge it as your will. Like I said, all in your handwriting. If you meet all those ticks, then yeah, it can work. But, I've seen so much litigation over the years involving issues like this. I had one case that just ended about 6 months ago where brother and sister and stepdad were involved in some really projected litigation that just was expensive, long, lengthy, emotional. Ended up with a jury trial to determine whether the handwritten document was a will. And it didn't go well. So I would say if you can, make an investment in a will that has a self-proving affidavit on it and meets all the statutory requirements. That is one of the ways to avoid something like that. But if, like you said, you don't have money, the state does provide for the option of having handwritten or holographic will. So, yes, you could do that. You could also, here's an option for you. Okay, I don't know what your assets are, but you could have beneficiary designations, and then it avoids court altogether. Okay? Maybe it's worthwhile to sit down with somebody. Just saying. So, well, these are good questions, and I encourage you to send your questions, like I said before. So, I want you to be better prepared for the future and aging and the issues that come with it. They're complex. This is having a good estate plan. This is the best way to protect you, your family, and your assets. Okay? And I'm an estate planning and elder law attorney. I want to be your advocate here on Boomer Time. So please continue to watch. Send me your questions. And if you need some help, call me. Set up a strategy session. So if you want to schedule a strategy session, you can go to my website, nancycogar.com, and look at the Contact Me box there, and you'll be able to contact me. Or you can call me, 423-596-7220. That's my direct line, okay? Bottom line, I want you to be better prepared. Okay? I'll see you next time on Boomer Time.